and grant any such other relief as the court deems proper and just.
That was very enjoyable.
It was.
Yeah. I don't think the judge has ever seen anyone call out
Every affirmative defense.
Yeah, every affirmative defense is like, yeah, let me tell you why this one's garbage. Let me tell you why this one is garbage. Let me tell you why this one doesn't follow the rules. Let me explain how apparently the attorneys you see in this court don't understand the rules and can't use the rules.
Well, yeah, the magistrate upholding or saying, there's no reason to grant this motion to strike.
Right, like somehow there's no difference between affirmative defense notice and affirmative defense fair notice.
I want to pull up exactly what Woodfield, somewhere around here.
You can do a search, I think.
I could. So under Woodfield, affirmative defenses must provide fair notice so that plaintiff was not a victim of unfair surprise. But it goes, it's much more than that. Where is it? This was really good. And I am so excited to get the senior judge's take on it.
Yeah.
And, if we have to go to the Fifth Circuit and get the Fifth Circuit's take on it, let's go. Okay. I can't believe I didn't actually put more from Woodfield. So they came back and they said, well, she filed it too late. She's untimely.
Yeah, that's because their calendar and ticker system didn't account for mail service, mailing service.
And the judge said I'm not late, so.
Yeah. The magistrate said you were timely. Yeah, that's true. Defendants argue that they will provide adequate legal support in future dispositive motions, conceding their current pleadings are inadequate. Oh, this backwards approach violates basic pleading requirements. It would not be tolerated if the roles were reversed.
Well, that's true, but I can also see their side also, because it's when they're actually raising these affirmative defenses by motion that the judge actually sees or is actually able to look at it. Like, raising the affirmative defenses, it's just preservation.
But no, see, that's the whole point of the rules. You need to have sufficient knowledge of your case and your side of the issues to bring up real affirmative defenses that are going to apply. You can't just, because otherwise, if there's no facts and circumstances to support the affirmative defense, but you can raise it anyway, well, then that's where you get boilerplate pleadings that do not help narrow the issues. They could ask for more time.
Well, I agree they shouldn't have brought legally insufficient affirmative defenses, but some of the affirmative defenses could be sufficient without any factual specificity.
Like what?
Like Monell.
Monell's not an affirmative defense.
Well, they raised it as one. Municipal liability.
They raised immunity. Half raised some sort of sovereign immunity. They raised Mississippi tort claims. Now their 12C had mentioned that there's not sufficient facts for Monell, which is preposterous. But I mean, that's what they're going for. Yeah, I like that one too. Defendants suggest plaintiff should have requested a more definite statement rather than striking, while simultaneously promised to develop their legal theories in the future. This is contradictory. How are they going to comply with a more definite statement when they can't even develop they don't have anything to develop their legal theories? I can go ahead and stop the recording.
All right. Yeah, that's fine.
I love that paperwork.
Yeah, I do too. I'm really proud of it.